So very good afternoon everyone. So in the previous session, start recording. So in the previous session we started with, we completed all the three doctrines under the Companies Act. All the three doctrines in Companies Act have been completed in the previous class, mainly the doctrine of indoor management, doctrine of constructive notice, and the doctrine of ultra vires. All the three concepts have been completed. Now in this lecture we are going to start with section number 10 first. So once we complete section number 10, then we will be done with doctrine and other related contents. Once those are completed, then we will be moving on to the next very important area after section number 10, called as incorporation and related sections. There are around 6 topics are there. We will be targeting on those 6 areas. Clear? So let us start with the concept. Before going into that, yesterday's session, all the three doctrines, everyone understood the content clearly? Just for a while I will give you time. Let's revise all the three doctrines for 5 minutes. Once completed, we go to section number 10. Please read it. Don't waste time. Please read the contents clearly, please, everyone. So next one, indoor management. So next one, exceptions to the doctrine of indoor management. Next one, doctrine of ultra vires. Next one. So completed reading the concept, everyone? Okay. Next, doctrine of ultraviolence, one case law also we have read. Please also read the facts of the case and conclusion. Why means once we complete this chapter again, in this session I will not come back to these concepts. So read the facts of the case clearly. Completed? Okay. Which rule was used? Interpretation rule? Oh. So also read the verdict of the court. Shall we complete, everyone? Shall I continue? Listen now. So we have completed all these concepts. See here. Please. See here now. Okay. First, now we are going to read connected sections to this memorandum and articles concept, connected issues. Let's see what are all the sections that are included into this. What are the three sections? See the screen and tell what are the three sections. Section number 15, section number 17, section number 10. Now we are going to deal with section number 10. Clear? Actually 10 should come first. In the charts mentally it will come at the last for one good reason. I can put it in the first place, but problem is section number 10 is also having another one page of discussion is there. See here. This is all about section 10A. If I write at the beginning, I can't fill these entirely. So therefore first I completed 15, later 17. In the balance page I first covered section 10. I continued in the next page in part B, like 14th topic. Okay. So actually we should read section 10 first. After 10 we need to go for 15 and later we will go to 17. And later we will go to section number 6. With that, memorandum articles related concepts in this chapter will get completed. Clear? We started with the definition of what is MOA, what is AOA. After 6 classes, we have now completed entirely the concept of MOA, and we have to, not yet completed, another 20% topic is still pending. So we are now going to start on with section number 10. So everyone please come to the Bayer Act. Section number 10. Let's see here. And please everyone listen. Important concept. One case law is there. Hello everyone. Listen. One case law is there on this issue. On section number 10. One case law is also there. Major General Shanta Shamsher Jang Bahadur Rana versus Kamani Brothers Private Limited. A case law happened in Rajasthan. Honorable Rajasthan High Court has given a judgment on that case. Very important for exams. Asked around 6-7 times with a change in names. So with the change in name, one attempt they will ask director, another attempt they will ask solicitor, another attempt they will ask advocate. Like that they change the names. Concept remains the same. Sorry, let me explain first the concept. Later that we go into the analysis. First, before going into this, let me summarize some concepts. As per the doctrine of constructive notice, memorandum and articles once registered with ROC, they become public document. Therefore, every person dealing with the company must first read the contents of MOA and AOA, okay, and understand the contents of MOA and AOA in a right sense. Second one, if that be the case, if you do not follow the doctrine of constructive notice, you will not be protected, company will be protected. So, it is a doctrine which presumes that you read MOA, you read AOA, you understood the contents of MOA and AOA in a right sense. It is a presumption made by the company against the persons dealing with the company. Second part, there is a doctrine which will be protecting the outsiders against the company, and that will be the doctrine of indoor management. Doctrine of indoor management will protect outsiders against the company. Outsiders need not inquire into the internal irregularities of a company. They will presume that all the internal things what they have to do as per MOA, AOA, they have also done correctly. That is a presumption of an outsider on the company. This is the second doctrine. Exceptions are there, knowledge of irregularity, suspicious or speculative transactions or negligence is involved, or forgery cases. Clear everyone? Later, after putting all these things, we went into the doctrine of ultra vires. This is a discussion that we have made in the last class perfectly. Okay, sorry. Now listen carefully. My question is, at the beginning of these doctrines, I said one point, insiders and outsiders. Who is an insider? Member in a member capacity will be treated as a insider. All other persons will be treated as a tell me now. Director, debtor, creditor, preference shareholder, debenture holder, member in member capacity. Now the question arises, sir, what do you mean by insider? Separate legal existence concept of what we learned in CA Foundation, company and members are one and the same or different? Everyone, company and members are not one and the same. Company is different, members of forming the company are different. Both are two different parties. No one is an insider to company. Company is a different part totally. But why we call members as an insider is a query. Clear? Let us try to understand clearly why members are called as insiders. First point number 1. Tell me, outsiders are protected by doctrine of indoor management. Company will be protected from the outsiders under doctrine of constructive notice. This is what we have already learned. Is there a doctrine like this for members? These doctrines are written for outsiders, insiders, everyone. This is not for members. This is for outsiders. For members, is there any doctrine like this? Answer. That's section number 10. 10 is a doctrine for the members in a company. Outsiders are covered by doctrines. Insiders are covered by the act itself. Therefore, what is the need for a doctrine? That's why they didn't include members into that doctrines, since there is a separate section to cover them. Clear or not, everyone? Tell me, what is the idea behind constructive notice document? What you have to read? What you have to read? MOA. What you have to read? Understand in a? That's the need for a doctrine, yes or no? That was said in section number 10 for members. That means, tell me, members are covered outside the Companies Act, in the Companies Act? Which section covers them? Everyone, repeat once again. Members are covered in the act, outside the act? That's why I call insider. Not company insider, Companies Act insider. Everyone understood the concept? Inside the Companies Act, members are covered, not inside the company. Company, no one is an insider, no one is an outsider. Company is a separate entity from members and directors. Companies Act, members are covered. Means inside the Companies Act, who is covered? Who is not covered? All others other than members are covered in the act, not covered. Therefore, we call them outsider. That's the meaning of outsiders, insiders. Outsider means outside the company register office building. Members means inside register office building. Not that. I'm not talking inside, outside in a physical substance. Inside, outside the act. First point, everyone understood the logic of insider, outsider. Insider means inside the act. Outsider means outside the act. Not outside company, inside company. First point, everyone had clarity, yeah? Done. 1 point over. Second, what is given in section 10 is a content now. Start reading. Everyone, section number 10. Start. Subject to the provisions of this act, the memorandum and articles shall, when registered, stop there. Constructive notice, what is the first line we read? Hey, constructive notice, what is the first line we read? MOA and AOA when registered. Same words are used also here because this is for members. Clear, everyone in the class? Now tell me, one second. Listen. Outsiders are bound by the memorandum or not is a question. They have to read the memorandum or not? Sorry, now read this. Start from the beginning. Subject to the provisions of this act. Continue. The memorandum and articles shall, when registered, bind the company and members. Stop there. That means already Act A created a binding effect between whom and whom? Company and members. Therefore, members need not be covered again inside the doctrine. Clear, everyone in the class? Start from the beginning. Subject to the provisions of this act, the memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed by the company and by each member and contained covenants on its and his part to observe all the provisions of MOA and AOA. Like that he said something. Not something that itself is everything. That's what we are going to understand by interpretation. Interpretation means what? Giving a right meaning to the phrases and words used inside the act, or else court will see us like a buffoon. When we go to NCLT Company Law Tribunal, when you go to High Court of Hyderabad, okay, without knowing about subject matter, case facts, without knowing about interpretation of sections, if you go na, first round lone knockout. No adjournments, nothing. First round day you are knockout. So therefore, the point is very clear. Whenever there is a listen here, don't drag them here. Listen. Listen. So great timing. Sir, listen. Point is, whenever the memorandum and articles, array, listen here. Listen. You want it? You take if you want. But listen. Yes, sir. Last day of law class, full party. Okay? But today is not last day. Last day, that's why I will take through Zoom. I will be saved. So, listen carefully. Effect of memorandum and articles. Sir, listen. Effect of memorandum and articles, members are covered here. So, subject to the provisions of this Act, memorandum and articles, when registered, bind the company and members. Other than members, please. 1 second. Please. Company and members it will bind. Company and members it will bind. Why it will bind? Because signing will make a binding agreement between two people. Signing. Daskat. Signing. Once you sign on something, it create a binding effect. Okay? Sir, I will give you an example. At the beginning of our Companies Act discussion, starting almost when we are in third floor or first floor? Same class, huh? But did I discuss about the definition of member to you? At that time, that rain, only few students came. That's why. I remember the room. Okay. I was never wrong in memory. So, that point was discussed when we are in that floor. But rainy season, rains are there. At that time, so many students slept through Zoom. If you remember. At that time, I discussed this concept. But still, it's my duty to revert to the concept. Point is, how to become a member is a debatable point. How a person can become a member? 3 ways are there. Technically 3 points, 5 ways. So people don't even remember. How many of you remember here? Definition of a member. 5 ways of becoming a member. Poor connection. Which connection? Brain connection. How many of you know the concept of what is a member? How to become a member? I will repeat here. Let me go back. Great performance again. Member. See here. %95 of the class are not even confident about the definition of what is a member. Sir, see here. Hey, at least now learn here. Waste of time for me, waste of time for you. You are not understanding. Please see there. Concept which is already discussed. At that time, I repeated 5-10 times. This will become multiple times again. See there. I don't want to repeat so many times the same concept again. Please. 1 or 2 times I will tell. Please listen carefully. See the screen. Everyone have the Bayer Act? How many of you don't have Bayer Act? Please come only with the Bayer Act. If you don't have Bayer Act, please leave the class. Tomorrow you can attend again. So please, I am very particular about that. Without Bayer Act, what you will do in class? So please see there. I told you, you need not buy also. At least take a printout. Do something. But have Bayer Act in class. When I am teaching everything from the Bayer Act, what you will read if you don't have? Sir, see here. Definition of a member. Let us see now. First, read the definition clearly. Member, in relation to a company, means the subscriber to the memorandum of a company who shall be deemed to have agreed to become a member and on its registration shall be entered as a member in its register of members. Every other person who agrees in writing to become a member of the company and whose name is entered in the register of members of the company. Every person holding the shares of the company and whose name is entered as a beneficial owner in the records of the depository. These are the 3 points. Sir, I will give 2 minutes time. Read properly, word to word, everything. Already we discuss, again I am rediscussing, means show some respect on that concept, to read properly. Once you complete, I can make my discussion on that area. Please read. before reading, tell me the word used is means or includes a? Means, means what? Are basic lectures, did you really listen properly, everyone? What is the meaning of the term means? Whenever means is used, how to interpret? Exhaustive, not exhausted. Exhaustive and restricted. Means you can give any meaning, you can give only that meaning. Therefore, there is only 3 ways of becoming, 3 points of becoming a member. Clear? Read now. There is no 4th point possible. 3 points are there. Don't delete anyone, don't add anything. Completed reading? See here. Member in relation to a company means only there are 3 points of becoming a member. You can become a member in 3 ways. Technically 5 ways in 3 points. Number 1, become a subscriber to the memorandum. Once you become a subscriber to the memorandum, on registration of company, you shall be deemed to be a member of a company and shall be entered as a member in the register of members. Number 1. Every other person. What do we mean by every other person? Any person other than subscribers to the memorandum who agrees in writing to become member of the company and whose name is entered into the register of members of the company. For third one, every person holding shares. Like that he said. I will ask you one question, answer. This question I didn't even ask the first time when I discussed this concept. I didn't ask this question to you, but still I have a question to ask. Tell me, when I have 3 points, I have written like this. Every person. Second one, every person. Third one, I can write every other person. Whenever I use the word every other person or any other, it should come at the last actually. Did you understand what I said? Clear? Sorry, I will tell like this. In our previous day example, I will take and I will explain. Lion, any other animal, comma tiger. Does this statement has any meaning? Lion, tiger, and any other animal. Does this statement has a meaning? Yes, answer. Yes, why second point, first point don't have a meaning? Any other means it should always come in the middle, first, last. Everyone. But in the definition it came in the second part. In that way you read now. That's called as interpretation. Till now what you have done? Reading. Court don't need your reading. Okay? You are not reading any story. Court don't need your reading. Court need interpretations. Did you at least understand the question what I asked you now? Whenever I use the word any other, where you have to read any, where you have to write any other, last one you can write any other. But here surprisingly, the word any other has come in the middle. Can anyone tell? Yes. No, no. Next. No, not that difference. That is very visible, clearly visible point. No. Next. No, no, no. Next. Agreeing, that was very clear. Next. Yes. No, no. So what? If I shall I tell you how you are telling the answer? Listen. In Sunday newspaper, books will come. Every Sunday a book will come along with the paper. They will ask you, identify the changes. Tail is there, tail not there. Dot is there, dot not there. Eating grass, not eating grass. I am not asking differences. Why you are telling here member is there, here depository is there, here tail is there, here tail not there. I am not asking you differences between two sentences. No, no, no. Next. Yes. 1 second. Third one. Similar to second point. Cause. No. No. Wrong. In the third case, up to there only I can hear. What is the relation between my question and that answer, bro? Everyone is giving answer correctly, but that answer is not for my question. I asked why they use the word any other person in the middle means you are telling other answers. I'm not denying that your answers are wrong, but my question is not corresponded with that answer. I'm not asking what is the difference between two statements. Yes. You only. No. Who is that? Who is that? Give title to movie first. Stand. I couldn't see you from here. Done. Now tell. No, 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 no. Second one can happen after also. Shall I tell you one thing? Bro, for you only. This answer dedicated to you. See the screen once. Then in the TV you see. Member of the company. The company. Already company is there. Sorry, shall I tell the answer? Yes. No, no, no. There also they will buy the shares. Next. Yes. No, next. Any other? Last one chance. No one? Sorry, I will only answer. See here. Generally, hey, listen here. Generally, the word any other, all these things should come at the last. But surprisingly, it came in middle of two things in this definition. So, first point number one, you should always remember one thing. With this rule you should read the act. Lawmaker will never commit mistakes. Even in terms of punctuation like comma, full stop also they don't do mistakes. Sir, I will give you one question, answer this. Plural will come first or singular will come first in the phrases of speech? When you use a phrase in the figures of speech, singular will come first or plural will come first. Member or members are member. Student or students or student. Answer. Which will come first? Huh? Very good. What should come next? Reverse can happen. Kada, please open section number 174, subsection number 3. 174 2, sorry. Section number 174, subsection. Oh, you don't have the Bayer Act, huh? Sir, then I will only show you. Sir, see here. Okay. Please. Listen. The continuing directors may act notwithstanding any vacancy in the board, but if and so long as the number is reduced below the quorum fixed by the act for the meeting of the board, the continuing directors or director. Words also I don't forget in Companies Act, which section, which subsection, which word has been used. Which phrase, which comma, where comma is there, where comma is not there. Section 180, subsection number 1. I am not telling joke sake. 180 section, there is a twist point. Section 180. Yesterday I shown you 181C. In that section 181C, 180 subsection number 1, class number A la comma will be there. C la will be there. D will be there. But B la comma will not be there. On that interpretation started in court. 180 section la. See here. To sell, comma is there? Are answer. Yes, to borrow money. To borrow money, comma there? Yes, next, to remit, comma is there? To invest, after this comma will not be there. Okay. There should be some intention of lawmaker, or else he will not miswriting anything. First belief is lawmaker never commit mistakes. If you check like this in direct taxes, how many sections we made? We miss sentences directly. Comma, full stop, keep it away. Para we will miss. We don't read within the para, we don't read properly again. So word to word interpretation if you start making, that's why I always tell, whether that can be any subject, learn between the lines, read between the lines. That means something you want to tell. Don't just like that, like a newspaper, to invest otherwise and trust security. Like that you should not read. Sir, just for understanding sake, to tell the importance. Tell me, 180 subsection number 1, class number A, what is covered? To sell, lease, otherwise dispose of. Clear? When companies sell the property, here, yesterday only we read this, to borrow money where the money to be borrowed together with the money already borrowed will exceed the aggregate of paid up share capital, free resources and securities payment apart from the temporary loans obtained from the company's bankers in its ordinary course of business. That is what said in 181. Too much ragging here. So, that's, please, don't distract. That's what 181C says. Listen, 181A to sell. 181C is, read there, what is the activity? To borrow money. What is 181D activity? To remit. Okay. What is 1B activity? Wrong. That's what I want to tell. To sell, to borrow, to remit is activity. This is to invest otherwise in trust securities. It is not to invest. Okay, read 1 second. What is this? Read now. Okay, listening everyone. Like that, one comma is a change from here to here. That's all. Your game may change. So one British official by mistake, rather than putting comma at the last, he put a comma at the beginning. It became hang him not, kill him. They said like this. So after that, one comma is there to this side. They immediately thought that hang him So immediately they killed him just because of the change in a comma. After that, whenever the British officers used to write any comma, they used to write comma and round it off. Array, here there is a comma, please check properly. Punctuation plays a crucial role. When it comes to act, more and more important. To remit, to borrow, to sell, but invest after comma is not there. How to read that? You should not read to invest. Like that you should not read. To invest otherwise in trust securities. That's the meaning. Clear? Likewise, they're also in the same way. Listen, I will explain you the concept now. First point number one, what definition we are reading? Definition of what? Member. See here. The point is, the word any other person or every other person has come in the second part rather than coming into the third one. Why? See here. First case, second case, I become member through the company. Third one, I become member through the stock exchange and depository. Simply to tell, if you want to become a member through the company, I can buy the share or not? Answer, yeah. Today I want to buy the share. How to buy? Today I want to buy the share of TCS. I will go to Mumbai to TCS company and I will buy share. From whom you should buy? Everyone. Everyone. That comes under third category. You are not buying from company. You are buying from whom? Therefore, your name will not be recorded in the company's register. Your name will be recorded in the depository's register. First point. First, second, if you see, you are buying the share from the company. First category is incorporation time. Second category is IPO time. When company went for an IPO, everyone listen, company went for a, you are buying the shares from whom? From the company directly. Now tell me, through company, how many ways are there? Not listening, start from the beginning. Through the company, if you want to buy, how many ways are there? Only two ways are there. When two ways are there, I will use the word every other person in the second category. Clear or not? Through company, if you want to buy the shares, how many ways are there? Number one, at the time of incorporation. Second one, other than incorporation time. First one. This is not the way to answer. Everyone is not answering. Start from the beginning. Tell me, I can become a member totally in how many points? 3. In that 3, how many directly through the company? First type, at the time of incorporation through subscribers route. Okay, na? Then if there are only 2 routes available through company, automatically if this is not the case, second one will be called as what? Every other person. That's why they use every other person in the second category. Everyone understood the point clearly, yeah? That every other person, why use somewhere in the middle mean? It's not in middle, it's at the last day. Last for what? Company's list, it is a last one. Clear? Third category, if you see, company is not involved. I am holding the shares of company, but I am not buying from the company. I am buying from whom? Some other shareholder. Sir, you are in Delhi. I am in Chennai. Example. Through online demat account, I purchase the shares. I purchase from the company. I purchase from another member. That means who is not involved? Then why I should write in first 2? Now did you understand the point? There are only 2 ways through the company. Third one is other than through the company. That's why they used every other person in the second category. Everyone understood the concept clearly? Yeah? Read now. Take a minute time. Read it properly. At least now properly. Last 2 minutes I will discuss. I will go to the section number 10. Shall we continue? Listen. You can become a member in 5 ways. 5 ways. Way number 1. At the time of incorporation, 2 clauses will be there. Clauses are capital clause and association clause. Everyone tell me what are the 2 clauses? Capital clause and association clause. In which book it will be, in which document it will be? Memorandum of Association. Capital clause la I will write the names of the persons who are agreeing to become the members immediately on incorporation. Clear everyone in the class? Those people who become the members of the company immediately after incorporation, we call them as subscribers to the memorandum. This I discussed initially. But so many students are not even having a clarity on this. I will repeat one more time. Listen carefully to the concept. Point number 1. Whenever the company is incorporated or yet to be incorporated, memorandum I will prepare before getting incorporated. Simply, memorandum of association is a document which will be drafted before incorporation of a company. In that, one of the clause is capital clause. Another clause is association clause. Association clause la I will write the names of subscribers to the memorandum. Capital clause la I will write the name, PAN number, number of shares agreeing to subscribe, price per share. I told all these things already when we discussed the capital clause of memorandum in this class. How many clauses are there in memorandum? 6. What is the 5th one? Capital. Capital clause la what details we write? First serial number, name, PAN number, number of shares agree to subscribe. That means by the time I am preparing the memorandum, company is already there or not at all? Answer. That means I am writing and promising to a unregistered person or non-existent entity. Therefore, in the memorandum of association capital clause, minimum 7 persons in public, minimum 2 persons in private will make a promise saying that I will subscribe for, say for example 5,000 shares of rupees 10 each. Yesterday I have shown you one SPICE document, if you remember. Do you remember a SPICE document? In that SPICE document, if you see, I will show you how the capital clause will look like. Maybe after that, if you get clarity, we'll be very happy. See here now. Yes, this is how it will be. Tell me, this particular person, number 1, first subscriber, Mr. Shivashankar Reddy, this particular person, so we will give educational qualification. So area of occupation others. What is his qualification? What he is doing as of now? He is a Vice Chancellor, Kale University. So he is a doctorate. He is a managing director. Also promoter. Also is a promoter of this company. He is a chairman and executive director. So details are given here. He is staying in Vijayawada in Andhra Pradesh. So the details are given. Now see here now. That person subscribed to equity shares or preference shares? Equity. How many number of shares subscribed? How much amount he agreed to pay? Now tell me, you should use your common sense. This form is prepared after getting incorporated or before getting incorporated? That means in this document, they have really taken the shares. They promised to take the shares. When they will take the shares? Actually, after getting incorporated. But in this MOA, they will sign. Who will sign? Subscribers will sign. This is a private company or public company? Private. How many members will be there? 2. Husband and wife are directors. They are the members, they are the directors in that company. Okay. Now their son also added. But original intention is wife and husband started that company. This is the idea. Sorry, now listen carefully to my point. Subscriber to the memorandum is a person. Subscriber to the memorandum is a person Who will sign on the memorandum at the time of incorporation? I will take a book called as memorandum. In that memorandum, last page will be there, called as association clause. Association? Say, for example, I took the same example also in the Zoom live classes on that day. For example, take a book. Say 100 pages are there in the book. You turned to the 100th page and signed there. Now you are accepting only that 100th paper. You are accepting 1 to 100. Answer. I signed on 50th paper. Then I am accepting 1 to 100, 50th page, 1 to 50. Whatever is unsigned, I am not accepting those. Yes or no? Yes, if I sign on the first page, I am accepting all pages. First page only. That's the point. That's why always signing will be at the last page. That's why last clause became association clause. All association persons will sign on that paper. I told you this point already during the Zoom live classes. But I worry now whether you heard those concepts or not. That's why. That's the main point here. So therefore my logic is very clear. Listen carefully. My point is, whenever a company is there, memorandum will be prepared. Last page to the memorandum is called as association clause. Association clause, how many persons are subscribing to the shares, promised to subscribe, their names we will write. 7 members required to start a public, those 7 names will be there. 2 required to start a private, those 2 names will be there. In which clause? Everyone. Tell me, what is the first clause? Next, situation. Next, last. Now last paper is what? Now in this book, last page I signed. Means I am accepting name, situation, objects, liability, capital, or all the clauses. That's why association clause become last. Or else association is the most important clause in a company, because those only started company. Clear or not, everyone? Those people only started the company, but they will stand in the last because they will accept all the remaining contents of the memorandum and articles. Sir, up to here everyone understood the logic clearly, everyone? So my intention is to make you understand this concept very clearly in detail. My point is, whenever the company get incorporated, STM will be the first persons who will become the members. Now listen, though I repeated for 15-20 minutes, hopefully everyone at least now you understood the concept. So tell me, at the time of incorporation, what documents we will sign? MOA. MOA, which clause you will sign? If you sign on association clause, it is real that you signed only on association, you signed on all the previous clauses. One signature you will make at the end of association clause, accepting all the previous clauses of memorandum. Up to here everyone understood? Yes, now tell me, I am signing on MOA today. I didn't even file Spice Plus. Who I am then? I am signing on MOA. Please be in this world, everyone. Physically people sit here, but the mind, face is index of your mind. Do you know what does it mean? You will see me, but mind will not be here. You might think that I don't understand, but I am not a damn bloody fool. First point number 1, face will be to focus on me, but mind will not be here, and it's clearly visible. So please listen carefully. Point number 1, again I am repeating. Whenever a company gets incorporated or yet to be incorporated, I didn't even start a company, I am drafting MOA. I signed on association clause. Filed or not yet filed? Who I am then? Subscriber to the memorandum. My name is called as what? Subscriber to the memorandum. Done. I filed Spice Plus form. Linked forms I attached, I sent to ROC, MCA website. My company incorporated now. My company got incorporated. Now tell me, who I am? Who I am? Deemed as a member. You need not separately become member. That's the first point. That's the first way of becoming a member. You need not apply for membership. All STMs will be deemed as members on incorporation. And your name will be entered into the register of members. To explain that, I explained all these things. Read. This is the meaning of first line in members. Read now. The subscriber to the memorandum of a company who shall be deemed. Who shall be deemed to do what? Deemed to have agreed to become a member of the company, and on incorporation what will happen? Shall be entered as a member. So tell me, caterpillar type life la 3 stages will be there in case of members. First I will be called as, when I will be called as subscriber to memorandum? Before incorporation or after incorporation? Company incorporated, immediately I will be deemed as a member. I will give you 180 days time. How many days? 180 days time. In my example, Mr. Shivasankar Reddy, that one of the director of the company, promised to subscribe how many shares? 5,000. Price each. Total amount. That has to be given to the company within 180 days. Then you will become shareholder as well. Now did you understand the difference between member and shareholder? Can you become a member without becoming a shareholder? Yes. Can you become a shareholder without becoming a member? Yes, that is also possible. You buy the shares, don't ask for membership, you just become a shareholder. I told you this point also in Zoom live session. If you tell no, you slept on that day. Shall I tell you what example I have given? I bought the share in the morning, sold in the evening. What membership you need now? What you will do in company by taking membership? Membership cost will be the profit. For example, if you take membership now, to apply for membership, charges will be there. 10 rupees or 5 rupees, charges will be there. 5 rupees profit, whatever you obtain from the share, you will lose in membership fees. Therefore, no fool will do like that. When I just want to speculate on the share market, buy share, sell share, buy share, sell share, intraday trading, then in that case, why the hell you need membership? At that time, you will only become what? Shareholder, but not a member. First point, everyone up to here understood the point. Now full-fledged we completed point 1 in section 2 class 55. We didn't even start with our section 10. First member la, how to become a member la, first point completed. Okay na? Second one. Other than this, any other way from the company, I became a member by subscribing the shares at IPO or at the time of FPO, or through transfer, or through transmission. All other cases will come under which category? Second category. Third category is trading. You are buying from the stock market through, I'm not telling buy, it's through. One person is somewhere, another person is scattered somewhere, he want to buy the shares. From company you can't buy, therefore you will buy directly from whom? Stock exchange. That means company don't even have knowledge about who is buying and selling its shares. Therefore company is not involved. Through stock market you will do with an entity called as a depository. That's the third category. Clear everyone? Now we completed the definition of member. Member definition we completed. With this basics, we have to start section number 10 now. Read this definition for one last time. We go to section 10. How many days of? There is no such date. You have to apply for membership. Yes, yes. Dividend will not come to you. Dividend will go to member. Completed everyone? Oh. Next. So we completed section 2 class 55. Member definition completed. Now can we go back to section number 10? 1 second, everyone tell me what is section 10? Effect of MOA and AOA. On whom? Members. Clear everyone? On whom? Members. Very good. Let's come to section number 10. See there. Effect of memorandum and articles. Let us see. Subject to the, please, subject to the provisions of this act, read, the memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed by the company and by each member, and contained covenants on its and his part to observe all the provisions of MOA and AOA. Language is very tough to understand. Take a minute time. Read first. We go to the analysis. So covenant means agreement. Attending general meeting is a power to member, not to shareholder. Getting dividend is a power to member, not to a shareholder. Like that, so many areas la members say covered, not shareholders. Members, not shareholders. Shareholders are not covered by act. Members say covered. Okay, well, shall we continue? See here. Doctrine of constructive notice and doctrine of indoor management has covered whom? Start from beginning. Doctrine of constructive notice and indoor management covered whom? And not the members. Members are not covered because members are covered by section number 10. Clear everyone? But you have to observe clearly the word. In this entire section, what is the important term? Everyone in the class, if you tell one word each, one point will definitely become important. So don't tell like that. Don't act too smart. Tell me what could be the most important word here? Registered. Listen, writing MOA is not enough. Writing AOA is not enough. What I have to do it? Registered. But what is the importance of this word registered in the entire section? Sorry, please see the screen once. Will you everyone please see the screen? Yes, sir. Shall I continue? Yes, sir. Listen. The memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they are respectively signed by the company and by each member and the content covenants, etc., etc. is telling. Now listen carefully to the point. Memorandum and articles shall bind when registered. Now the question starts. Tell me. I will take a paper. In that paper, I will collect the signature of 1, 2, 3, 4, 5. 5% signature I will collect on a paper. Okay. Remaining persons in the class, didn't sign on that paper, will you be liable other than these five? Will all other persons in the class be liable for the contents in that paper? Will not be liable. Will be liable, will not be liable. Huh? Why? Because we didn't sign on that. Simple answer. Who signed? First five signed. All of you signed or not signed? Therefore, whoever signed, those people only will become liable to whatever is contained in MOA and AOA. Yes or no, everyone? Repetition one more time. Tell me, I will take a paper. 5 persons' signatures I will collect. 1, 2, 3, 4, 5. First bench 5 persons. Now tell me if they sign. If they signed, they only signed. Remaining all other students of the class didn't sign on that. You become liable to the contents covered in that paper. Huh? No. Why? 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 Huh? So whoever signed on the paper only will become liable to the sheet. Other persons who didn't sign, they won't become liable because they don't sign on the document. Sir, if I don't sign on some document, even for that if I am liable means I will liable for everything in this world. Clear? So therefore, I will be liable only to such a document where I have signed. Now question number 2. He used the word registered articles and registered MOA. Registered articles and registered MOA. What do you mean by a registered articles and registered MOA? Bro, you are seeing mobile phone, that mobile phone screen visible on your spectacles. You are the biggest fool on the planet. If you want to see phone, remove that specs and see. Sometime after I can see what you are seeing. So, listen here, sir, let's leave. Listen. Hey, listen here. So the point is, so whoever want to see mobile phone, see, no problem. But remove these. Don't behave like a fool. What you are seeing is also visible sometimes. So see here. Point is, whenever transaction happens between two persons, both the persons or 5 persons or 10 persons or some number of persons has to sign on that. Once you sign, it gets a legal validity. When legal validity is not there, you can't bind that person in the court. Bind means making him liable in the court. Legally, if you make someone liable, we use the word binding. Now the question starts. 5 persons signed on a paper does not mean others who didn't sign are liable. Yes or no, everyone? Yes, if you observe the words used in the section, subject to the provisions of this act, the memorandum and articles shall, when registered. Now tell me, registration will be done at the beginning of incorporation, during incorporation, after incorporation, after 10 years? After 10 years. Registration of MOA and AOA will be done at the time of incorporation, after getting incorporated. My question is for everyone in class. No exemptions I have given. No proviso. Okay? Answer everyone. So point number 1. Articles and memorandum registration will be done at the time of incorporation, after incorporation? At the time of incorporation or before getting incorporated, it will be registered. Okay, I am not talking about alteration of articles, normal articles, original. Okay, registration will be done only once, at the beginning, during, at the last. At the beginning. Okay, now tell me, at the time of registration of a company, I repeat, at the time of registration of a company, MOA and AOA will be registered with ROC. At that time, who will sign on MOA and AOA? Last page, who will sign? How many required for public? Private? Say for example, 1, 2, 3, 4, 5, 6, 7. These 7 persons are STMs. All STMs signed. They registered MOA with the ROC. Company also incorporated. After that, public issue happened. We all came. Clear? Company issued shares. We all joined company. Now tell me, we all signed an MOA, na? We all signed an MOA, na? How many signed? How many didn't sign? All others, other than 7, signed or not signed? Therefore, who will be liable on the contents of MOA and AOA? 7, all? All. That's what the intention of the section. As if though signing is really done only by the subscribers, I will bind all the members as if they individually signed on MOA. Did you understand the point, everyone? For that reason, section 10 has been inserted in the act to tell that members, you are also bound by constructive notice and indoor management, but in the act itself it is there. That's section number 10. Sir, anyway, please read the point once. Read. Subject to the provisions of the act, the memorandum and articles shall, when registered, bind the company and the members. Stop there. Bind the company and the subscribers. Bind the company and the members. Means any member. That's why I made you to read the definition of member now. You may be any category of member. Continue. Thereof to the same extent. No, not like that. As if has some stress on that. Read. That doesn't mean, yeah. Come from the beginning again. The memorandum, start. The memorandum and articles shall, when registered, bind the company and members thereof to the same extent as if they respectively had been signed. Stop. What do you mean by they respectively had been signed? What do you mean by they? What do you mean by they? MOA and AOA. Read properly. Adverb, verb, adjective, pronoun, no difference. Read again. They does not mean members. They means MOA, AOA are plural. Read again. There is no wrong in putting BCR in a foundation. Bro, you will not read. You will be gone, I am saying you. You didn't see second phase. You are gone. Please read properly. Now tell me, the memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed. Stop there. They respectively have signed, they didn't tell. Had been signed on the documents as if both of them have signed. I mean, MOA and AOA, as if every member, for example, 7 members started at the time of incorporation or after. All of us, we signed or not signed? I deem that you have signed. This is a fiction created by law. I told you, legal fiction. This is another classic example. As if means deemed. As if they respectively had been signed by company and by each member, and all the contained agreements on its or his part. So tell me, as per doctrine of constructive notice, what an outsider is expected to do? Read MOA, Read AOA, understand the contents in a right sense. Yes or no? Same thing. The members also should observe all provisions of memorandum and articles. This is indoor management and constructive notice for members. Hope you understood the logic of the section, everyone in the class. Very, very important concept. Examination, that's why they multiple times they will ask. So everyone ensure that you are reading this section properly. Once on the stage, don't commit mistakes. I expect you to answer at least 80% of this answer should be replicated again. Words and phrases also you remember properly. The memorandum and articles of a company shall, when registered, bind the company and its members thereof to the same extent as if they respectively had been signed by the company and by each member, and the contained covenants on its or his part to observe all the provisions of MOA and AOA. Clear, everyone? Next. If shareholder has promised that he will pay call money, first call, second call, and if he don't pay, member capacity will be converted into debtor capacity. That's what they said in second case. All monies payable by any member to the company under MOA shall become debt due from him to the company. Immediately he will become whom? Debtor. Member come debtor. This is all about section number 10. With this, we have completed section number 10 as well. Done. Everyone understood from the background till the concept? Small section, but lot of conceptual discussion we made. We went to member definition, we read member, we understood STM, we understood all the modes of becoming member, came back, we again read this concept, understood insider outsider, who is insider, who is outsider. After that, why members are called as insiders, and member being an insider, what will be the impact. STM only will sign on MOA and AOA, but still all the other members will be applicable as if they respectively signed on MOA and AOA, and member becomes a debtor if he does not pay the amount due by him to the company. With this, we have completed section number 10. Here we completed this. So, section 10 as a section A we completed. One case law is there. That case law will complete. Close section 10 related case law also. Nothing will be left out for our what is a clearance in this concept. The case law what I am going to deal now is not there in your study material. That I have given in the charts material directly. Study material they didn't give this. Okay, they only given the name of case. They didn't explain anything. I will give reasonably a good explanation than that. So let us see what it is. See the screen once. Other issues on binding effect. Everyone please see the screen. Later you can read everything. First point, effect of MOA and AOA. Please read impact of registered MOA and AOA. Read. MOA and AOA shall bind company and every member as if MOA and AOA. I have clearly written here. I didn't write the word they. I know where they commit mistakes. So therefore I have clearly written MOA and AOA. Read. As if MOA and AOA respectively had been signed by company and each member. Next, obligation on the member to observe all the provisions of MOA and AOA. Amount due to company as per MOA and AOA shall become debts due and shall be paid, or else he will be treated as a member come debtor of a company. Clear, everyone in the class? This is one part that we completed. Section 10 over, but 10 related case laws are there. Let us see that concept. See here. Read this. There is a binding effect between company and members. Company shall be bound to member. Example I will tell you. Shall we continue? Company in its AOA has said that whenever call is made, first call, second call announcement will be given first. Whenever call announcement is given, money should be deposited in the bank account of the company within 21 days. Like that I have written in the AOA. Listening or not, everyone? I repeat once again. In the AOA of a company, what we have written? Whenever call money is made, whenever call announcement, I think you know application allotment, first call, second call, final call. First application money over, allotment money over. I am calling for first call. Announcement also made. After making announcement in the AOA, I have clearly written within 21 days we should receive money. Clear? A person is there. Say for example, this person. He deposited money 18th day. Valid or not valid? 18th day. Valid or not valid? He deposited money. Money also received company. Company said that we received late, therefore we are forfeiting your shares, it said. Now tell me, company is bound by AOA, it is going against to AOA. Yes, that's what we mean by company bound to members. If you say something in AOA, you do the same to the members. You should not go against to that. Clear? Next, there is a binding effect between members and the company. Same, reverse case you think? Member also have an obligation to pay within 21 days or not? So member is also bound to the company. In a private company, I have written like this. In a private company, I have written like this. If any member want to leave the company, other members only should buy the shares. Don't send to outsiders. Now tell me, if a member want to leave a private company, it becomes obligation of the existing members to buy that or not? Therefore, memorandum does not create, there is no binding effect between member with another member generally. In these kind of agreements are there, then only liable, or else generally member will not be bound by another member. So two things. Tell me now, company bound to member? Company AOL I have written some, sir, company objects clause, construction is there. Can you do furniture manufacturing? Because it is going within the objects, beyond the objects. It is bound by MON, not bound by MON, which is wrong. Like that same way. Tell me, company bound by MOA and AOA? Company is bound. I am asking a question. Do they requirement that company should be bound by its memorandum? Now tell me, company bound to members? Yes. Members bound to company? Yes. Member bound to another member generally? No. Everyone? Next, last one important point. Company bound to the outsider. On this only one fantastic case law has come. That's called as, please read the name of the case law. Major General Shanta Shamshe Jang Bahadur Rana versus Kamani Brothers Private Limited. This particular concept, this particular case law happened in the Honorable Rajasthan High Court. What happened in this case law? Let me explain the facts of the case. If I show like this, immediately you will not remember, listen to the concept. Therefore, first listen, after that you can read. Point number one. Now I will ask you one question, answer this. When there is a section called as section number 10 to cover members within the objects of the indoor management and constructive notice, why can't I include also outsider into it? I repeat once again. See here. Doctrine of constructive notice and indoor management will cover whom? Members or outsiders? Section 10. Why can't I include outsiders also into section 10? Why lawmaker wouldn't have included? Please, listen. Or else you can't understand the question so easily. Listen, please. Final students could not understand this type of questions. So please, listen first. After that, I will ask you the question. Point number one. You have written a section called as section 10. In 10, who is covered? Members are covered. Okay, na? Means if something is there in the MOA and AOA, members should strictly follow that. Member has come and said, hey, I am not a subscriber, I didn't sign on association clause. But we tell, as if you signed, you are already bound. Every person need not sign on MOA. Clear? This is the idea of section number 10. Section 10 makes automatic binding effect to the members with company and company with members. Both. Company bound to members. Members bound to by whatever is contained in MOA. If MOA la something is said, na, company should follow. Members also should follow that. Clear everyone? Because it is an agreement between whom and whom? Company and members. Company is a separate legal person or not? Can it enter into its own agreements or not? Therefore, it enter into agreement with its members. Done. Section 10 came. Why can't I include outsiders also into that? Why can't I create an automatic binding effect also to the outsiders? Any guess? Why can't I create a section for outside? Why doctrines are required? Sorry, okay, 1 or 2 cases like doctrines came. Even after that Companies Act amendment made or not? 2013 new Companies Act is drafted or not? Even then they didn't write. Why? No, we will tell them outsiders only. Why can't we write? Insider, outsider, leave off. Why we are not including others other than member capacity into the section? Any guess? No. One second, ma'am. Who is telling the answer from that side? 1 second, I will come. No, that was said in doctrines. Again, you are linking doctrine to that. I am telling why there is a need for a doctrine. If it is there in Companies Act, at least I can ask some person. If it is not there in Act, how can any person understand? Who is that? Who is that? Yes. Whether, sorry. Means what? No, someone raised hand from the last? Yes, sir. In case of liability, I couldn't listen. I am very sorry. In case, loudly. Next. Outsiders. Any guess? Liable for the? So, what is the link between the question I asked and the answer given? I am asking, why can't outsiders become part of this act? Why can't we destroy the doctrines and keep something inside the act itself for them? Why can't we tell a provision similar to a member to also to the outsiders? That's my question. So what? We will tell them outsiders only in the act. You are trying? No, okay. Next. Companies Act is applicable. Madam Parlak, please say. Companies Act is applicable only for? Companies Act applicable for companies, yes. We are members. I am individual. They are entering into contract, kada? I am asking, why can't indoor management, construct notice, everything become part of Companies Act? Why can't we have a similar section like that? For example, company is bound to members, yes sir. Company member bound to company, yes sir. Company bound to outsiders is no. Why? Yes. Members also, all members don't come at the time of incorporation. That's what I'm asking. Why can't we write a section like this, connecting memorandum and outsiders? Sir, listen carefully. Yes. Yes, sir. Why? Any person other than member is an outsider. Very easy to define than member. Very easy to define than a member. Sorry, okay. Let me explain this point. If something you write in MOA, it will bind a member or not? I repeat once again. Everyone be in this world 5 minutes. Point number 1. Whenever you write something on MOA, whether the contents you write on MOA will bind the member or not? Again I am asking, listen, understand, give your brain some digestion and then give them answer. Point number 1. If I write something in the MOA, whether it will bind the member, legally, not illegal, legal, within the company, I have written something in the MOA, will it bind the members automatically? Answer. Because of which section? Which section? That means separately each and every person has to sign on MOA, na? Not required. We signed at the time of registration. Okay, as if everyone have signed, everyone will be bound by the MOA, yes or no? Now tell me, I have written something on MOA. Example, whenever call is made, you have to pay within 21 days, I have written. No member can say no to that. They can't tell that, at the time of registration I was not there, I didn't sign, therefore I will not pay within 21. You can't tell like that. That means something I write on MOA, it binds all. It binds all. It binds all. It binds all. If I write something on AOA, it binds all. Automatically. That automatic binding effect you can't create with outsiders. Good reason number 1. I will give you one example to understand. Your name? Ram Kumar. Okay. So, sir, listen. Mr. Ram Kumar is there. I have taken the MOA or I have taken AOA. In the AOA, 92nd clause I added. Employees clause or employment clause. Okay. In that employment, he is a professional employee in my company. It is there in which document? AOA. Which one? AOA. This section covers MOA and AOA. 2 documents. They have been respectively signed. Means AOA is also covered or not? Be in this world, everyone in the class. I took MOA, AOA. In that I opened AOA. 92nd clause I added employment clause. And I have written that Mr. Ram Kumar, Chartered Accountant and Company Secretary, is bound to attend to the duties of the company from morning 6 a.m., night 10 p.m. Okay, at a monthly salary of 500 rupees. I have written on AOA. Now answer again. First point, which document I have taken? Everyone remember, I am writing your name respectively. If I tell Ram Kumar, not just Ram Kumar. If you are some XYZ, you put your name. I wrote your name. Mr. or Miss so and so person will be my company's internal auditor come compliance officer who will come to the office at 6 a.m., who leave the company at 10 p.m. on a monthly salary of 500. I have written like this. Where I have written? Very good. Now you will come, will not come. Hey, MOA written binding effect. Come. That's what I want to tell. This is what a binding effect of MOA with outsiders. You can't create a binding effect of outsiders with the company through MOA and AOA because outsiders will not come like that. If that be possible, I will write name of Ratan Tata. Every person in India will take AOA. Mr. Ratan Tata will become director of my company from morning till evening. For another 20 years I will write. Are you understanding or not? If I write like that, Ratan Tata has obligation to come. Ante my AOA create binding effect with the outsiders. That's why never it can form part of Companies Act. Clear or not everyone? Not now. Even after another 1 lakh years, I may be reborn again to teach the same Companies Act. At the time also binding effect of this concept may not be there. Are you understand the point or not? I may be reborn again to teach the same FMO, same Companies Act, same finance, but concept doesn't change, because wherever Companies Act is written worldwide, binding effect can never bind the outsiders. It can bind only insiders in company, because it can't create any magnetic effect between company and outsiders. So then how it is possible? That's why outsiders will enter into separate agreement. At that time they should read MOA, AOA, understand it in a right sense. Clear or not, everyone? So take a break and come, we'll continue the concept. So let's continue. So we are into the case law. Let us understand the concept. See here. So articles and memorandum will create a binding effect between company and members bound by company. Company will be bound to the members, but outsiders in company, there will not be any kind of binding effect. I told you the reason also. Just because of writing something in the articles and memorandum will not bind the company with the outsiders. You have to separately write an agreement with them, or else it will not be binding. Now the question, on this a particular case law has happened. That case law is important for exam. See here. There is a person called as Major Rana. Huh? Sorry, listen, please. He is the Gubert Rana. He is not a normal Rana. Sorry, okay. Anyway, see here. Major Rana is a particular person who worked in the Indian Army, retired, and went to a company. Their family members and relatives have started a company. In that company, he joined. Listen carefully. Major Rana was appointed as a managing director of a company called as K Private Limited, Kamani Brothers Private Limited. In that company, he became a managing director. Clear? Listen now. Articles of association of a company provided that Major Rana cannot be removed as a director. I repeat, Major Rana is a managing director and 10% shareholder of K Private Limited. In the articles of association of that company, it was written that Major Rana cannot be removed as a director, okay, unless there is a proven misconduct. Misconduct itself is not enough. It must be proved in the court. If that be the case, you can remove him, or else in all other cases you can't remove Major Rana as a director. This is what provided in the AOA of a company. So I repeat, Major Rana is a MD and 10% shareholder of a company called as a K Private Limited. AOA of that company provided that Major Rana cannot be removed as a director unless and until there is a proven misconduct. Like that it was written. Clear, everyone? Yes, I went. Step number 1. Step 2. After 2 years, the company decided to remove Major Rana as a director. In this company K Private Limited, shareholders have passed an ordinary resolution in a general meeting, and they have safely removed Major Rana as a director. As a director. They removed him as a director. So I repeat, Major Rana is a managing director and 10% shareholder of K Private Limited. Articles of association of K Private Limited provided that Major Rana cannot be removed unless and until there is a proven misconduct. K Private Limited conducted a general meeting, passed a ordinary resolution and shareholders have removed Major Rana as a director. Up to here everyone understood? First one, the act of removal is first he was removed though there is no proven misconduct. Though there is no proven misconduct. Okay. Now it is justified or unjustified? Unjustified removal. Unjustified removal. Now listen. K Private Limited appointed Major Rana and continued or removed? Come from the beginning again. Major Rana is a managing director and 10% shareholder of a company called as a K Private Limited. Articles of association of the company provided that Major Rana can't be removed as a director unless and until there is a proven misconduct. K Private Limited conducted a general meeting. Shareholders, by passing an ordinary resolution, removed Major Rana as a director though there is no proven misconduct, and the removal happens to be unjustified. Now first point, answer my question. Can Mr. Rana go to the court and claim any kind of relief against this unjustified removal or not is a question. Yes or no? Answer is a big no. It is not possible because Major Rana entered into agreement as an outsider because you are not removed as a member. You are removed as a director. Director to the company is an outsider capacity. He is not an insider. Whatever you write in the AOA, MOA with an outsider, that does not bind. Therefore, court has given a judgment that happily you can remove him, though there is no proven misconduct. I will show you two routes available to this. Route number one, see there, what happened in this case law. Major Rana was appointed as a managing director. He is also a member. Shareholder means I mean a member. MOA, AOA will bind outsiders or members? Rana is an outsider or insider? Both. He is an outsider in capacity as a director. He is an insider in capacity as a member. Company will bind members or outsiders? Company MOA, AOA will bind outsiders or members? In member capacity he is removed. In director capacity he is removed. Answer? Means outsider or insider? Outsider. Outsider cannot be removed unless and until there is a misconduct. Like that, where it is written? Like that, can I write or cannot write? Why? AOA can't bind outsiders. Therefore, even though you write some nonsense, it will not bind. Even though you write Vedas, it don't bind. With whom? Therefore, the conclusion thereby given by the court, happily you can remove Major Rana because of one good reason. Number one, articles will not create any binding effect with that of outsiders. I am not removing Rana as a capacity as a member. I am touching him in capacity as a director, which is an outsider's capacity. Clear or not everyone in the class? That's one very, very important case law. Read that. The company in its AOA has expressly said that MD of the company cannot be removed unless there is a proven misconduct. Read. Major Rana has been appointed as a MD of the company. Major Rana is also a member of the company. Read. Major Rana has been removed by the company as MD even though there is no proven misconduct and filed a suit in the court against unjustified removal. What is the judgment given by the court? Court in the given case has held that removal of MD claiming it to be unjustified is not valid since MOA and AOA do not create any binding effect with the outsider. Here Major Rana is outsider or insider? Both. He is an insider as a? He is insider as an outsider. Which locum you are sitting? He is insider as a? He is outsider as a? I am removing him in capacity as a? Means an outsider or insider? Will outsider and memorandum attach? That's all. That's the judgment of this case. Everyone understood the concept clearly? Yeah? So that's a fundamental mistake that person has made, and this is how it will be. Therefore, whenever you are entering into a company with any agreement, if your agreement is there in AOA or MOA, it does not bind you. Clear? That's why if you see, one point will be there. First auditor cannot be appointed by naming him in the AOA, they will tell. First auditor of a company. Have you heard this? First auditor of a company cannot be appointed by naming him in the article. This is the reason. He is an outsider. You can't create any binding impact of appointment. That's the reason. Did you understand the concept, everyone? First auditor, who should appoint? Members has to appoint. Sorry, first board has to appoint. If board fails, members will appoint. I'm not talking about the audit point of view. Only it's Companies Act, na? If it is Companies Act, it is enough. So, company, whenever first auditor has to appointed, first auditor has to appointed by the board of directors. If board fails to appoint, who can appoint? Members can appoint. That means appointment should be made only either by the board of directors or by the members of a company. Extremely, central government will appoint. So, leave off. Nowhere, articles you can't write the name of first auditors. Whose name? Articles. Articles you can't write the names of. You can't write the name of first auditors. You can't write in articles. Why? If you write in articles, Mr. Kaushik Mukesh, chartered accountant in practice, will be the auditor of our company. You write there. Where? AOA, MOA, you have written. Company incorporated. I didn't come. I didn't come to your company. Now tell me, can you sue me? You cannot, because articles don't create link with me. Then your company will become auditorless. Clear, everyone? Or reverse case. In the AOA you have written, Mr. Kaushik Mukesh will be appointed as a auditor of our company, who is a CA in practice in Hyderabad, with a monthly remuneration of 5 lakhs you have written. I joined. I worked everything. 1 month over. You paid only 5 rupees to me. I want to file a complaint against you. Can I file? I cannot, because articles don't create any relation. Therefore, auditors, directors, never you should write anything about them in the articles, because they don't create any kind of binding effect with that of the company. Everyone understood the point clearly? Yes, that's all. So then how come this type will be protected? Enter into separate agreement, write on a stamp paper. I cannot be removed unless and until there is a proven misconduct. You write in a separate agreement. Those will be binding. Writing in articles will not bind the outsiders. Everyone understood the point? With this, we have successfully completed section 10 and analysis attached to that. Now we completed that small section, section number 10. Now we have to complete connected section 15, 17 and 6. 15, 17, 6. Okay. Please open the Bayrack. 15, 17 and 6. First come to 15. One minute answers, very easy to understand. Please see here. Everyone please see here. What is section number 15? Alteration of memorandum or articles to be noted in every copy. Sir, what does it mean? I will give an example. Tell me, MOA and AOA are which document? Very good. They are public documents. Okay, na? That means whenever public want to access, those will be visible for the public access. Anyone take. Now listen. My name is XYZ Limited previously. I altered MOA and made it ABC Limited. Name changed or not changed? Change. Alterations made or not? Whenever alteration is made in MOA and AOA, that alteration should be given effect in the next printed MOA and AOA. Whenever you are giving a printed book of MOA and AOA or PDF you are putting on website of your company, updations should be made. That means whenever you make an alteration, that alteration should be reflected in the altered MOA and AOA, or else punishment will get attracted. Answer over. That's what section 15. One line answers are nothing great. Please read. Every alteration made in MOA and AOA of a company shall be noted in Every copy of memorandum or articles as the case may be. If company makes a default, amount will be attracted. I told you penalties I will give as a separate chart. That's all. What is the section we completed now? 15. Now 17. Now question will come. Whenever articles MOA amended, whenever you want a copy of articles, public documents are not a public document. From where I can get it is the question now. From where I have to take the copies of MOA and AOA? 17th section will deal about it. Everyone read. A company shall, on being so requested by a member, send to him within 7 days of the request, subject to the payment. Therefore, it's not free of cost. It's a free access, not free of cost access. That's what I told you even in the previous class. MOA, if you want a copy, payment free? Payment is required. Clear? Free of access, free access, free of cost access, free access, free of cost access, free access, free of cost access, free access, not free of cost access. A company shall, on being so requested by member, send to him within 7 days of the request, means including that day, and subject to the payment of such fee, a copy of each of the following documents. Each of means every single document separately you need to send. Number 1, MOA. Number 2, AOA. And the third one, just read and leave. When we come to management and administration chapter, you can understand. Just remember last, agreements under section 117. That's all. Remember like that. Agreements under section number 117. And in so far as they have not been embodied in the MOA or AOA. Next, if the company makes a default, punishment will get attracted. Punishment section, I will give the chart. Penalty chart I will give. So tell me now, first 17th section, one second, I will come to you, 1 second. 17th section, the content what we are going to cover is, company has to give MOA and AOA, okay, has an obligation to send a copy to every member monthly, annually, or only on a request? Who can request? Who can request? Member can request whom? Can whom? And company should honor the request and send it within how many days? Free access, restricted access, free access, free of cost access, payment. What are the 3 documents covered by this section? And agreements under section number 117. Clear? But one small point. Here only members are covered. Who is not covered? Outsiders are not covered. Sir, outsiders want to see, sir. Then what to do? MCA website. Then you can't ask a company, you are not a member, na? Go to MCA website. MCA website left side corner, master data will be there. What data? Give the SIN number of the company. Which company you want? Click. Directly they will give list of around 200-300 documents they will give. Which document you want to buy? You have to give the detail, make the payment, per page rupees 10 rupee, you pay, it will get downloaded, come to your Gmail account directly. That's why they are not talking about that in this. Here I am talking only about whom? Members. Outsiders has to take only from MCA website, not from company. Clear or not everyone in the class? This is all about section number 17. If you don't provide a copy within 7 days, penalty will get attracted. Same website, yes, you can do. But members also have this chance. For example, if you want to apply from the MCA website, cost will be decided as 10 per page. Okay? And here it is not like that. And moreover, here I can go directly to the company and take a hand delivery immediately. You can't do like that. Here physical copy will be given. There only electronic copy. If you want physical copy and you have a reachability with the registered office, you can go for this option. If not, you can go directly to the second one, pay online, you will have the access. So just read the bare act, a minute time, we'll go to the next one. Sir, what are the two sections we completed now? 15, 17. What is section 15 saying? Tell me. Whenever there is a alteration in MOA and AOA, every copy should contain such a alteration. If not, penalty will get attracted. Penalty irrelevant, we can see the charts. 17th section will be talking about taking the copies of MOA and AOA, but the power is given only to whom? Can request whom? Company should give it within how many days? If they don't give, what will happen? Penalty. That's all. Nothing great. Section number 15, 17. Chances of asking an exam very, 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 very less. What is there to ask? These are procedural sections. Very less chance will be there to be asked in exam. Very, very less chance. But there in the syllabus, we have to read. Sorry, up to here completed everyone in the class? Next, what is the section I said you? 6. Someone asked you one question yesterday. Sir, can memorandum I can write against to the act? Someone from this side, they asked. Who asked the question? You asked. Read. Everyone, again we came to somewhat a different area. Act to override MOA, AOA, etc. If you observe the word etc, if you see, ejusdem generis. Section heading lane ejusdem generis is there. Read the section content once again. Act to override MOA, AOA, etc. Everyone tell me, what do you mean by etc? Constitution of India, Income Tax Act. Then something related to the company. Documents relating to the company. When you compare, act will be superior. But still, let us read together. Start. Save as otherwise expressly provided in this act. Underline this. Why? So this is interpretation of statutes point again. I have to interpret this properly. I will show you examples. Save as otherwise expressly provided in this act. Start. The provisions of this act shall have effect notwithstanding. Stop. What do you mean by notwithstanding? Ignoring. Means what? Ignoring. Ignoring. Notwithstanding mean ignoring. Detail so many times you might have seen this. Direct taxes la. Salary chapter it will come, house property it will come. Because whenever transaction happens on PGBP, so many times the word notwithstanding will come. Notwithstanding means this section and another section, if they collide with each other, which will win? No, that section only will win. Sir, okay. When it comes in our subject, I will explain this. Okay. Leave it. Sir, okay. Leave it. 1 second. Save, please read. Save as otherwise expressly provided in this act. The provisions of this act shall have effect notwithstanding anything to the contrary. Stop. What is contrary? Contrary means against or differently. Don't make your own English interpretation. This is legal interpretation. Contrary means different. Anything to the contrary contained in MOA or AOA or in any agreement executed by it or in any resolution passed by the company in a general meeting or by the board of directors, whether the same has been registered, executed, as the case may be, etc., etc. And any provision contained in MOA, AOA, agreement, resolution shall, to the extent which is repugnant. Repugnant means going against. Going against. to the provisions of this act become or be void as the case may be. Read this section clearly. I will give you 2 minutes time. Please read properly when I ask you to read. I'm making it full screen. If you want, you can see from the screen directly. Please read when I give time for you, please. Save as otherwise expressly provided in this act. The provisions of this act shall have effect, notwithstanding anything to the contrary contained in the MOA or AOA or agreement or resolution passed by company in general meeting or by board of directors, whether registered, executed, anything. Any provision contained in the MOA, AOA, agreement or any resolution, to the extent they are repugnant to the provisions of this act, become or be void as the case may be. That's what provided in section number 6. Sir, summary, let me tell you. Not tell you, you should only tell me rather. Tell me. Act MOA. Who is bigger? Act. Act AOA. Act agreements. Act resolution in general meeting. Act resolution of board of directors. That means who is superior? Anything you write against to the contents of the act, who will win? Act A will win. For example, I will tell you. Act illegal object, unlawful object is prohibited by section 3 of the act. It should start only for a lawful objective. Did we read or not section 3? In my MOA I have written, our company can manufacture, produce, boil, brew, or for that case we can make a grounding and selling of heroin, cocaine, opium, crocodile drug, all these things. Now tell me, memorandum objects clause it is their main objects, valid or not valid? Why I have written in MOA? But this is going against to section 3 of Companies Act. Everyone now understood the concept clearly? Yeah? Next, second example. In my MOA I have written, the company shall pay taxes if and only if the MD like. Now tell me, can I go like that? No, because the object of your company is to evade the taxes. Again, you cannot. That means if you write something in MOA, AOA, it will override the act or will not? That's the idea behind this point. Basically, this is the idea. Okay, let's read again. Save as otherwise provided in this act. Start. The provisions of this act shall have effect, means shall only apply, ignoring anything differently contained in the MOA, AOA, agreement, resolution of general meeting, resolution of board of directors. Means I am comparing act with how many documents? First tell me that. 5 documents I am comparing. Tell me, act is compared with how many documents? 5. Everyone list. MOA, AOA, agreement, resolution of general meeting, resolution of board of directors. But I am not satisfied. Everyone from the beginning to the last. Start. Number 1. AOA, agreement, resolution passed by the company in a general meeting, resolution passed by the company in a board meeting or board of directors. Now, act, any of these 5 documents if you compare, okay, in these 5 documents I have written something against to the act which will take effect. Act documents are. Act A will take effect. Ignore these contrary things. That's what you want to mention. Everyone understood the point clearly? Yeah? Sir, I have written something nonsense in MOA and AOA agreement, etc., which is against the act. What will happen to that nonsense? It becomes void automatically. That's all. This is what you want to tell. Nothing greater than this is there in section 6. Okay? But one thing I have to explain you. What is that one thing? Save as otherwise expressly provided in this act. Everyone, one last time I am asking, tell me. Act MOA. Who is superior? Very good. Ante articles should act according to the articles. Articles should act according to the Companies Act. Companies Act should act according to the articles. Very good. That means who is superior? Act or articles? Act or articles? That means who will influence whom? Articles influence act. Act will influence articles. Act will influence articles. Articles will influence act. So who is superior? Who is inferior? Yes or no, everyone? Sorry, give me a minute time. Sir, you are asking this much means something different you will show you now. I understood. You read this. Hey, everyone, please listen. Section number, please see there. Everyone. If you observe the wordings of section 161, the articles of a company may confer on its board of directors the power to appoint any person other than a person who fails to get appointed by the company in a general meeting as an additional director, who at any time who shall hold the office up to the date of next annual general meeting or the last date on which annual general meeting should have been held, whichever is earlier. This is what said in. If you please don't deviate the main topic. See there, if you listen here please. Starting lines of the section, if you see 161 subsection number 1, additional director. The articles of the company may confer on the board of directors. Confer means officially giving a power. Okay, who should give? Has to give power to whom? Answer, yeah. The power to appoint whom? Power to appoint whom? Any person other than a person who fails to get appointed by the company in a general meeting as an additional director at any time, comma. Clear? After that, remaining things will continue. Okay, na? At any time, who shall hold the office up to the date of next annual general meeting or the last date on which AGM should have been held, whichever is earlier. This is a provision. But first line say golden words. Who will appoint additional director? See and tell. You read and tell, no problem. Slowly you read. Who will appoint additional director? See and tell. Zuma. First line is important. Don't read other lines, unnecessary. You tell me now, who has power to appoint additional? First tell me, which director we are talking about? Section number, subsection number, which director? Now tell me, additional director can be appointed by whom? Everyone. Only. Board only can appoint. Okay, 1 point over. Board shall appoint additional director. Okay. Board can appoint additional director directly. Power should be derived from articles. Read the point clearly. Don't sleep when you are reading. Okay. The articles of a company may confer. That means if articles it is there, that board can appoint additional directors, then only board can appoint additional directors. That means, listening everyone. Now answer my question. Who should give power to board to appoint additional director? Everyone. I will ask you one question. Who can appoint additional director? Who should appoint additional director? From where board is getting power to appoint additional director? Article. Now I will ask a contrary question to you. Articles la silent. Can board appoint or cannot appoint? Cannot. Cannot. I'm not talking alteration of articles now. Okay? Overaction not do. Only answer to the question. Okay? Point is, normally articles la silence is there. Nothing is there. Can board appoint additional director? No. Why? Articles did not officially give the power. To whom? Means which section will not get attracted? Now come to the line properly now. Tell me, which section we are reading? 161. Subsection number 1. Which director? Can we appoint additional director? I mean, board of directors can appoint additional director. Sumoto, directly they can appoint by deriving power. Who should give the power? Central government. Who should give? Now tell me, articles have given power. Who can appoint? So which section will get attracted? Article C is silent. Okay, Article C is silent. Can board appoint or cannot appoint? Means which section will not get attracted? Now who is influencing whom? Article C is influencing. This is the meaning of save as otherwise provided. Generally active will influence articles. But sometimes it is not true. Sometimes articles also can influence act in these cases. Same applicable also in case of section number 68. Same applicable also in case of section number 66. Same applicable in case of section number 151. Same applicable in case of section number 152. Subsection 6, class number A, subclass number 2. In all these sections, articles will start influencing the act. Therefore, they have provided save as otherwise expressly provided in this act. When we come to the respective areas, I will show you. Okay. Buyback is another area in our syllabus, IPCC syllabus, CA inter syllabus. It is there. Section number 68, subsection number 2, class number 3. In that subclass number 1 and 2, we will be seeing out the concepts as to how the articles will influence the act. Also, you will see in redemption of preference shares. Also, you will see in sweat equity shares, section number 52, subsection number 2, class number A, subclass number 1. In all these cases, you will get attracted by articles influencing the act. At respective places, I will show you. At least this everyone understood. One last time, tell me, who influences whom generally? Influences what? MOA, AOA, agreement, resolution GM, resolution of board of director. Sometimes save as otherwise expressly provided. If in any other section, otherwise means differently. In any section of Companies Act, differently if it is provided expressly, then don't apply that provision, go by that section. Clear everyone in the class? Now, which section we read and we came to 161? Section number 6. What is the starting lines of 6 Bear Act? Save as otherwise expressly provided in this act. If in any provision of this act differently provided, follow that. Nothing is said na, act will override all these. Clear everyone in the class? That's the meaning of save as otherwise. We also completed section number 6. Over. So what are all the sections we completed now? Can I know? Today what sections we completed? Today. First section number 10. 10 we read section 2 class 55 definition of member. First 35-40 minutes I spent on going back to the old concept. After that section number 10. 10 after case law. After that we came to 15, 17 and 6. As our target, all are completed. So with this we have completed second part of this chapter. 60% completed. Only 40% of this big chapter. There are 3 big chapters in our syllabus. Incorporation, share capital prospectus, administration management. That's all in that. This area will be completed. Another 40% is still pending. Those are incorporation related sections. Which one? Incorporation. Means procedure. Very important for exams. One question pakka from this 6 areas I am going to discuss now. Now we are having 6 concepts. From that 6, one question will come in exam. No doubt, including last attempt. Which 6 I can't tell. In that 6, which one will come you can't expect. But one from those 6 will definitely come in exam. Every attempt, take last 25 papers, every attempt one question will be there. That much important those areas are. What is the area? Incorporation and incidental issues. 6 or 7 sections will be there totally. We are going to discuss those. Before going into that, please come over to charts material once. At the beginning of the charts material, I gave you learning objectives. In the charts, what happened? Why screaming? What happened? Sir, see here. At the beginning of this charts material, I have given learning objective. You tell me, I will tick whether we complete or not. Basic definitions completed. Definition of promoter. Who is a promoter under section number 2, class 69? Every person who is identified as a promoter either by the prospectus or in the annual return. Second one, any person who has a control over the affairs of the company either as a shareholder or as a director. Any person according to whose advice, directions or instructions the board of directors of the company are accustomed to act. So, do you remember the point? Very good. Who is a registrar? Registrar means a registrar of companies including hierarchy, assistant registrar, deputy registrar, joint registrar, additional registrar, who will be exercising the functions conferred under the Companies Act and do the registration of companies under the Companies Act. Next, what is memorandum? Memorandum of association means memorandum of association as originally framed or as altered from time to time. Same also for articles. Next, clauses of memorandum. Tell me what are the 6 clauses? Name clause, situation clause, objects clause, capital clause, liability clause, association clause, or liability, capital and association. Next, formation of company. Minimum number of directors, minimum number of members to form a public company, 7. Private company, 1. Next, analysis of memorandum, okay. Do you remember the contents of the name clause? First one. Contents of name clause. Name clause will contain the name with which the company is proposed to be incorporated. If it is a private company, private limited. Public company, limited. Public company means public limited. And private company, private limited. Public company, public limited. Why public company, public limited? Public company will use which word? Limited. So, public company means limited. Private company means private limited. Public company, public limited, they won't use. One person company, brackets we need to add OPC. If it is a section 8 company, no need to use the words limited, private, limited. We have seen all those. Sir, everyone say yes or no to this. What? Yes, I didn't ask any question. See here. Reservation of name completed. Rectification. What is an rectification here? Tell me. Name is similar or identical or too nearly resemble to the name of an existing company or a name of an existing registered trademark. How many months time will be given to change? By passing which resolution? Ordinary resolution. Villain will be there in first row of the class. All wrong answers. Next. Had we completed situation class? Contents establishment of RO, shifting of RO. Shifting of RO of 4 types. Number 1, place to place within city, city to city within state, RO city, ROC within state, state to state. Next, analysis on objects clause. What is objects clause? Alteration of objects. Next, unutilized amounts of those concepts we read. Other clauses also completed. Alteration of articles, analysis or articles. Entrenchment yesterday, full stage. Next, conversion of public to private to public. Asal topic, doctrines. What are the doctrine? Doctrine of constructive notice, doctrine of indoor management, doctrine of ultra-wide, section 10, effect of MOA and AOA. Next one we came to incorporation related sections. Here how many concepts are there? 5. Incorporation of company section 7. OPC rule number 3, incorporation of section 8, section 8, declaration of commencement of business section 10A, effect of registration section number 9. We have to cover all these things. Okay. So once you cover all these areas, yes, this chapter will be completed. Okay. After that, miscellaneous some sections are there. Small, very small. Okay. Those we will read and complete off. Before that, please come to section number 7. Important concepts are getting started. See, this is a chart. Okay, see there. Once see the screen. This is a complete analytical chart on section number 7. This chart will explain you section number 7 in a clear-cut format. All the points have been included. Listen first. Please. Listen. We are having 4 topics in incorporation, as I already said. First one, general corporations, means incorporation. General corporation means generally how to incorporate the corporate entities. It's called as general corporation provisions. Section number 7. Second one, licensing for section 8 company. Next one, special procedure rule 3, 4, not just 4, rule 3 and 4. Part D, effects of registration, section number 9. First we need to complete this. First, name of the topic is incorporation of company, section number 7. In this, rule content only to some extent applicable for exam. That rule content I have clearly given and merged in the chart. Later we will read formation of company with a charitable object, section number 8. Once after this we will start with special provisions applicable only for which company? One person company. First, second, third, fourth, fifth provisions to section 3(1), rule number 4. Next, incorporation and other issues. Next, other issues in incorporation, section number, effects of registration. Next, declaration of commencement, section 10A. Punishment for fraud in incorporation is section number 7, 5, 6 and 7. After that, miscellaneous area 6. Already 6th one we completed or not? Yes. Next, 19th one is subsidiary to not to hold the shares. 20 is service of document, authentication of document 21, execution of bills of exchange 22. With that, this chapter will get completed. Okay. We have to start now with the last but one area to our subject in chapter number 2. What is the name of the topic? Incorporation concepts. Section number 7, 8, 9 and rule 4. 3, 4 will be merged in 4A. Okay. So 3 and 4, 4 rule. So we are now going to start with section 7. Please open the Bayer Act. Today we target on complete section 7. Once that is done, we can take up the remaining concepts by the next session. 8, 9 remaining we will complete in the next session. Let's try at least. May be completed, may not be completed. Let's make a try to complete at least. Please see there. Incorporation of company. Please, no noise. Please, 45 minutes. Please sit in the class and understand the concept clearly. 45 minutes, 40 to 45 minutes it will take. So please, see there. No interpretations, only procedure. Procedure means how to apply for Aadhaar card. If I ask a question, you will tell a procedure or not. We need a photograph, we need a proof, like that we are going to see. Already in this 60% I explained in SPICE. Previously I explained everything about the SPICE documentation. Yes, sir. So many times I repeated. Therefore nothing will be new for you. Every single point, whatever we read here will be having a clarity, we will be having an earlier discussion already. Nothing great, nothing new. Procedure, memory based answer, simply to tell. This is not interpretation based answer. These are memory based procedure, like GST. Like GST. GST is 60% memory based. Means than interpretative, they are making procedures. This company, this person, This is attracted, this is the filing, this is registration, this he has to do. Like that they said. That's what the difference between the old excise and the new GST. GST is very easy when compared to the old excise law. Because of one reason. Excise law is more about interpretation. GST is more about procedures. Because we have rules. Everything is said in rule. Always I said you at the beginning of our lectures, rules contain what? Numericals, procedures, form. Therefore nothing will be there. GST completely driven by rule content. Act is very small. Rule content will drive. That's why nothing great in GST. Old excise used to literally bring tears in the eyes of the students. Because of interpretations, act reading, everything. Like how Companies Act is there now. But GST has changed the total way. It became very easy to read, very difficult to practice. Student side like dead easy. Member side like very difficult. Because procedures are involved. Na? Every difficulty will come in a practical application. From an exam point of view, the easiest subject in CA final, generally students will tell is GST. 60% of the students don't even have coaching for GST. They will read institute study material, they will go to exam, they will pass. For one good reason. They do articles in auditor's office or not. Practically they might have already seen GST. Nothing great we are going to learn in class again. Therefore, first 60% students don't even take coaching for GST. They read book, they do practice. For inter, okay. You don't even have any background. Here, okay. But final time, you yourself will build an ideology in such a way that why GST require coaching. You will only understand. When you read something, you can only understand. You work with an auditor. 3 years, 2 years you will work. At that time, you will learn complete GST there. Practically. Not bookish knowledge again. Do you understand the concept, na? Sir, class life, I can tell law good, FM good means we practice on that. Therefore, we know in and out about that concept. Or else, how can we justify that? Just reading a book means how you understand, I will also understand in the same way. I do practice on the same thing which you read. You read, I read and practice on that. You read financial management, you put a formula, but we will do that work actually. That's why you will remember the concepts more often with regard to this. So many people also used to ask like you, not now. Recently one seminar was conducted in Coimbatore. Now next week announcement also will come on all the channels regarding me. Mangalore I am having a session on FEMA. Jan 9th. After completion of your class, I am leaving to Mangalore. There is a session on FEMA. So many chartered accountants will, I am not talking about students, I am not talking about classes, I am talking about seminar for members, practicing members who are having around 30 years experience or 25. Why Kaushik Mukesh is required for them? I am not even the age of their experience. For example, a 60 years chartered accountant came. 70 years chartered accountant will come. He will sit behind us. His age is 70. His experience will be 40. Our age will not be there like that. Then why he has to listen? But they will listen because knowledge updation. Because no one will have that much knowledge updation every single day. Only one person will have. Not don't tell my name. I'm talking about teacher. Correct teacher again. Subjected to that condition. So if we learn, update that every single day, definitely you will be called for. Recently I'm talking about Hyderabad, 2 seminars I have taken. One on exchange commercial borrowings, external commercial borrowings, how to take loans from banks outside India. If you want to take loan within India, 2 minutes. But I don't want to do like that. I want to take a loan from Barclays Bank of UK. I want to take $1,000 crore. How can I take? What is the procedure involved? Those are called as external commercial borrowings. In that 39 clauses will be there. Each clause a word to word interpretation. How we can do, how the law has suggested us to do. Like that same, FEMA only I am going to take because I practice more on finance and foreign exchange. So dollar, euro, every single day in our office we do that. So therefore what I am trying to explain is try to understand. You practice and read. You will become a gem of a guy. You read only book, no practice, half. I will not do both, sir. You can't do anything. You have bookish knowledge, good bookish knowledge, half work completed. You have practical exposure, balance half work is completed. Done. You are perfect. I do only practice. Only practical knowledge I have. You will not pass CA exam then. Seriously, so many people I have seen practical in my life. In my office, one person is there. His name is Ramakrishna. That person's age now is 47. Still writing exam. I'm not stopping him from writing examination. What I'm trying to tell is the zeal in him that to write. He started at the age of 41. I think you can understand that. They have intention to write exam. Age is not a limit for CA. Anyone can write at any time. We may know a person from Chennai, Mr. S.D. Bala. So he is from Chennai only. Very good friend of another popular chart accountant in Tamil Nadu. He is also once upon a time a faculty. S.D. Bala. He write book on accounting standards. Such a great person S.D. Bala sir is. That person started his CA at the age of 55. Completed one day before he attained 60 years. Birthday tomorrow, na? 59th year, 364th day, he became CA. Results came. So, you understand, God's script also will be in such a way. Exactly his birthday is in this month, January 19th. 18th, institute released the results. One day before he becoming a CA, 60 years, turning 60 years, he became a chartered accountant. 4.5 years he completed CA. So age can never be a limit. If you have a practical knowledge only, you are not good at reading the books, CA you cannot pass. I can read books, sir. Every chance is there you can pass, though you don't have practical knowledge. Like GST, that's what the example is. You don't practice on GST, but still you will pass GST exam. So CA requires reading habit. First sit. Okay, apply Fevicol and sit. Such that you will not stand often, you will not go. Apply Fevicol and sit, study properly, read. Though you don't have practical exposure, every chance is there you can pass. Sir, I have filed GST returns for my parents, father, relatives, sir. I know GST to some extent. You will not pass. Just with that knowledge, I am talking about that. Because in exam, he don't give you practical cases. In exam, he will ask you from the book. How you are about law, they will ask that question. Hope you can understand what I said. Same even in case of this. Spice plus form, attachments, agile form, all those things they don't tell in the act for exams. We practice that, therefore I have shown you the practical examples, how they will be. Do you understand now, everyone? Now, if you understand that, very good. Listen. Now we are going to understand the procedure as to how to start a company. For example, you are there. You want to take money from a person and you want to incorporate a company. You will get a doubt now, sir, how to start first. This is the section. Practically I will explain. Theoretically you will explain. Both I will merge and I will try to explain. Listen carefully. First point. Point number 1. Client comes to you. He asked you, please incorporate a company for me. First you should ask him question number 1. Which company you want? Publica, private? Often in India you will get answer private. Often, very often you will get a name private. They will tell, sir, private company. Who will be there inside the company? Answer that question next. And your parents are, you and your wife are, you and your children are, who will be there inside? Those will be called as subscribers to the memorandum. You need not educate all these things to them. Just you need to tell minimum how many are required. 2 are required. Who will be those 2? You will ask, sir, me and my son. Like that they will tell something. You write down the details. Next, how much capital is proposed? How much? Capital is proposed. 5 lakh or 10 lakh or some amount he will tell or not. On that basis, ask him each share price will be 10 rupees or 20 or 30 or some amount you will write. Done. Like this, you have to ask the questions. What Act has said is what we are going to read now. Let's start reading the provisions of the Act. Start. There shall be filed with the registrar. Everyone repeat. There shall be filed with the within whose jurisdiction the registered office of the company is proposed to be situated, the following documents and information for registration, namely, stop there. There shall be filed. With ROC, every state and union territory is having a ROC. I am starting a company in Chennai. Which ROC I have to file? Any ROC in India, na? No. ROC within whose jurisdiction RO of the company will be proposed to be situated. Tell me, I want to start my registered office at Westmambalam in Chennai. Now tell me, my company belongs to which jurisdiction now? Chennai jurisdiction. Chennai has an ROC or not? Yeah. To that ROC you have to file. Clear everyone? Simply to tell, ROC always represent jurisdictional ROC, not any ROC you want. Clear? 1 point over. Next, what are all the documents? Sir, always remember, whenever law uses the word namely, it represents, it is as similar to means. In DT, GST, so many times so you will see the word namely in the act. Namely always represents means. What is the importance of means in a definition? Same importance for the namely in the sections. Only those has to come. First, everyone answer. We should file with whom? Not like this. Everyone start from the beginning. We should file with whom? Which ROC? ROC within whose jurisdiction registered office of the company is proposed to be situated. To that ROC you have to file. 1 point. What we have to file? What we have to file? Listen. 1, 2, 3, 4, 5, 6, 7. How many attachments are there? 7 attachments are there. Okay, now these 7 attachments are the heart and soul of this particular concept. Once that is completed in the remaining section, just like that we can complete. 7 points, say heart and soul of section number 7. First, I want you to read sentence number 1. Start. MOA, a memorandum and articles of the company duly signed by all the subscribers to the memorandum in such manner as may be prescribed. For your exams, rules not applicable. Write down here if you want. Rules not applicable for exams. Sir, in the rules what will be there, sir? Form numbers will be there. What numbers will be there? Form numbers. INC 33 MOA, INC 34 AOA, INC 35 Agile, INC 32 Spice. You forgot Spice form. Spice form you remember? Huh? What is another name of Spice? INC 32, MOA 33, AOA 34. See here. See here. Okay, na? Satisfied? Huh? Everyone satisfied? Huh? Please read what is there. INC, form INC 33. Spice MOA. It is MOA. 34, 35. Agile form. Agile form means GST, insurance, all these legal compliances will be filed. I told you the other day. So therefore, please answer properly. Point number 1. The memorandum and articles of the company duly signed by subscribers to the memorandum in such manner as well. If you want, you can write INC 33 and 34 because he used MOA and AOA. MOA form number 33, AOA form number 34. Clear up to here, everyone? One document over. Ticket. Next. BC, don't read now. Come directly to D. Everyone answer my question. The moment I incorporate company, from the next minute, registered office will be there or will not be there? Everyone in the class answer to my question as per section number 12, subsection number 1, subsection number 2. Registered office of a company shall be established within how many days of the date of incorporation? Within how many days? 30 days. Means for 30 days period, a questioning time was given or not? In that time, I may not have my registered office. Yes or no? Within 30 days, first 30 days of incorporation, two things I have to do. Number one, establish a RO. Second one, file a verification of RO in form INC 22A. Did you remember the wordings? Now tell me, that means immediately when I start a company, I may not have registered office. 15 days la I got. Example. That means for the first 15 days, I have R1 or no R1. In that 15 days, I want to communicate with the company. ROC want to communicate. To whom I should communicate? Therefore, temporary address till RO is established. How logical they have written? That's the wording. So temporary registered office, that's called as a address for correspondence till the RO is established, means a temporary RO. You need to give an address. Next. Now, please listen carefully. Company will have two important organs. Number one will be board. Number two will be shareholders. Number one. Number two. Or number one shareholders. Number two will be board of directors. This is the point. Now listen. Subscribers to the memorandum should be minimum how many? Private? Come from the beginning. STM, minimum how many in a private? Public. Who are those 2 or 7? I want their name, surname, residential address, nationality, each and every detail about whom. Likewise, I require same information also for first directors. Two important organs you only told, na? Who are the two organs? Number one, shareholders. Number two, come from the beginning. No one is telling. Tell me now. Who are the two important organs for a company? But at the time of incorporation, shareholders will not be there. Who will be there? I want those people details. Details means full details. Like what you saw in my spice farm, I have shown you. Give the full details about them. And second one, I also want the details of first directors. Details of? Give their names, addresses, but along with everything what subscriber gave, director has to give DIN. What is it? DIN. Everyone try to explain the full form. Director identification number. How Aadhaar for Indian nationals, na? DIN is a identification for directors. Okay? It's a proof that you are a director in a particular company. That's a proof. Hope you are clear to the point, everyone. Right up? Please see that now. DIN. Already they will have DIN. DIN has a separate application. If you want to become director in a company, first apply DIN. Section number 154. If you want to know the procedure of DIN, read with rule number 4. Okay? If you want to reapply for DIN by alteration, rule number 6. If you want sections 153 to 159. 153 section, read with rule number 3 and 4 talks about how to apply for a DIN. Sir, DIN is having a procedure. Simple point. Sections leave out. DIN is having a procedure. First apply for DIN, get the DIN, later incorporate a company. Okay. Next. Tell me now, point number 1, address for? Sorry, what is the point number 1? Take 2 documents. Number 1, MOA, AOA, signed by all the subscribers to the memorandum. Over. Number 1. Number 2, address for correspondence till RO is established. Number 2. Number 3, read the point. Particulars of the persons mentioned in the article. Particulars of what are the things? Name, family name, residential address, nationality, and such other particulars of every subscriber to the memorandum, along with proof of identity as the case may be, and in case subscriber being a body corporate, such particulars. Anyway, such particulars not applicable. Just listen carefully. What are the things that are applicable? In a simple way, in the charts I will show you what details are required. Please see the screen. personal particulars of with respect to STM and FDs. Everyone tell me, what do you mean by STM? What do you mean by FD? Foreign directors, huh? With regard to the STM and FDs, what details we have to maintain? With respect to STM, everyone, name, surname, residential address, nationality, proof of identity. Along with all these 5, for a director, one another thing is added like a tail. That's all. For the directors, with respect to FDs, first directors, same as STM, means what are the thing? Name, surname, residential address, nationality, proof of identity, plus DIN. Plus what? DIN. Along with that, 3 other things. Listen, member need not give consent, but director is a contract because he is an outsider. Director is a member company are attached not by contract but attached by MOA. Attached by MOA. But director is a insider, outsider, outsider. Then how can you attach a relation between company and a director? By contract. Contract is not there without giving a consent that you have to give. Who should give? Who should give? Has to give his consent. He should give a consent that yes, I want to act as a director in this company. Interest. Sir, interest means not percentage interest. Interest means I am, one second. I am becoming a director in this company. Yeah? If you are a director in any other company or if you are a partner in any partnership firm, you give the details of those entities. Okay, interest means financial interest, managerial interest. Interest does not mean percentage of interest. Clear? Next, interest in other firms and body corporates. If there is any, please clearly explain there. 4 points I said now. How many attachments are there? Sorry, how many attachments are there? 7. In that, how many we completed? Let's clearly say that. Let's revise properly. How many? 4. First tell me. Number 1. MOA, AOA, duly signed by all the subscribers to the memorandum. 1 point over. Next, second one. Address for correspondence till registered office is established. With regard to members, subscribers, what detail? Name, surname, residential address, nationality, proof of identity. With respect to FDs, name, surname, residential address, nationality, proof of identity, director's identification number, consent, interest in other firms and body corporates. That's all. Everyone understood the point? First 4. Everyone, you revise along with me in the class, never you will forget again. If even after 20-30 days, if you read, you may not remember everything. But when you open, it doesn't look like new thing. Definitely you will feel that yes, if I read now 1 minute, I can remember you, that confidence will come. Sir, anyway, up to here, everyone understood the point clearly? Yeah? Sir, we completed point A, D, E, F. Next, G also. That G point I merged in that interest in other firms and body corporates. Okay, completed. So we completed all, except how many points? 2 points. Sir, what are those missing 2 points? Listen, these 2 points like common is declaration. 2 points, what is a common, sir? Declaration. Sorry. 1 second, everyone in the class, please listen. What declaration they will give? A doubt may arise. But even before answering that, I have a question. To incorporate a company, who will be incorporating a particular company? Who will incorporate? Means who will be there? Who will put money? Subscribers. Who will direct the company? First directors. Means these are the 2 persons who will be involved in the company incorporation or not. Now the question arises. Is there any guarantee that the subscribers to the memorandum should have a knowledge of Companies Act? Is there any need that the subscribers to memorandum have a knowledge on Companies Act? 99 out of 100 cases they don't even have a knowledge, because companies are incorporated not by chartered accountants. So many engineering company can be there, mechanical company can be there, software company will be there. So many companies, why chartered accountants will involve? Hospitals will be incorporated as company, doctors are chartered accountants. No, then how can they understand that there is a form, take that form, spice 32, INC 32, how they will understand all these things? Therefore, when I say Taj Mahal is constructed by Shah Jahan, he will not go and construct. You know this logic, kada? When I say who constructed Taj Mahal means who you will tell? Shah Jahan. That does not mean he really went to construct. Masons will construct. Bad logic. Like that same thing. When I tell STM incorporated company, STM will not file all these things. Chartered accountants will do. That chartered accountant will give a declaration. Clear everyone in the class, sir? Sir, only chartered accountant, sir? No. 4 persons were given that chance to incorporate company in India. Who are those? Everyone should live, not only just chartered accountants. Other professions are also there or not? Let them also live. So therefore, 4 professions were given a chance to start a company. Everyone start 1, 2, 3, read point B and point C. First B. A declaration in a prescribed form by an advocate, a chartered accountant, cost accountant, or company secretary in practice, who is engaged in the formation of the company, and by a person named in the articles as a director, manager, or secretary of the company, that all the requirements of this act and rules made therein in respect of registration and matters precedent or incidental thereto have been complied with. First read this B point. Completed everyone? First tell me, this declaration is self-declaration, professional declaration? Professional declaration. Who is giving? Professional is giving. Who are the 4 professionals covered? Advocate, chartered accountant, cost accountant, company secretary. These are the 4 professionals covered. These 4 professionals will give a declaration. Declaration about your behavior, your conduct? No, I am giving declaration that while incorporating this company, we followed Companies Act. We followed company rules. We followed the procedures under Companies Act. That's the only guarantee I'm going to give. I'm not going to give any other declaration. Declaration that the company is incorporated as per the provisions of Act and rules. By following those act and rules only, we have incorporated this company. Like that, who will give a declaration? 4 professionals, any professional can give. Please read one last time. Declaration in a prescribed form by an advocate, CA, CMA, CS, who is engaged in the formation of company, and also by whom? Person named in the articles as director, manager, or secretary of the company, that all requirements of this act and rules made thereunder in respect of registration and matters precedent have been complied with. Listen, important one is C. This is called as affidavit. Called as what? Affidavit. Affidavit means self-declaration. Everyone repeat, what do you mean by affidavit? Self-declaration. Declaration means one person will give on another. Self-declaration means I will give on me. I am a good person, I only said. That's called as what? Affidavit. And you will sign on that. If you are proved to be bad, you are gone. Clear everyone in the class? There is a section under Companies Act called as a fraud, 447. Section under Companies Act, section number 447. In auditors also it will come, sir. Auditors chapter also, in auditing, reference to the fraud will come, because auditor has to report frauds. Okay, report fraud, rule is there. As per that rule, he has to report about the fraud. So what is the fraud? What is a fraud? Under company, don't tell your meaning. I am asking what is fraud under Companies Act. Sir, why sir? Now fraud is, why it is involved, sir? Why fraud involved? Because he will be using here fraud. Therefore, first you need to understand what is the fraud. What is fraud? Auditing law, what you read, same. Not yet completed, huh? Okay. It will come, definitely it will come. Yesterday only I saw his book here, in that it is there. We discussed about that only. But he said it is not yet started. But if it starts, definitely the concept will come. Fraud has a definition under Companies Act. First time, Act defined fraud. So many acts, any kind of word which has a crime inside it, law don't define them. Example, murder is not defined in Indian Penal Code. Any of the language, foul words we use, there are no meanings under Act. If I have to define murder, lawmaker should explain how to kill. Therefore, never he will do that. Murder is not defined. It will be derived out of the cases. That's all. They don't define intentionally. Do you know the word casual vacancy? Word casual vacancy. Defined or not defined? Not defined anywhere in the Act. It will not be. Companies Act, you need not tell. The point is, casual vacancy word is not defined. They will not define. Auditors casual vacancy, directors casual vacancy, they don't define anywhere what is casual vacancy. Okay, because death, all these things will come. Why should I tell that an auditor should die? I will not. And sir, there is no death for auditors, sir. Don't put that question. The spirit is, Act want to be written only with a positive note. Sir, what is a casual vacancy, sir? Tell me. What do you mean by casual vacancy? It occurs casually. It's called as what vacancy? Casual vacancy. Sorry. Casual means generally emergency, sir. Casually represent emergency cases. Casually represents a general. Casually means generally, specially. Answer. Two persons are employed by an entity. I repeat, two salesmen are employed by an entity. Listen to my story properly. Two employees are employed by an entity. Sales. Two mobile phones were given by the same company to them. Take this mobile phone. Morning 9 o'clock you should switch on this. Your personal mobile phone is different. 9 o'clock we should get a message from you that you started. Evening 6 o'clock your work will be completed. Mobile phone should work from 9 between 6. Between 9 and 6 you should operate on this phone. Clear? Two salesmen are there, A, B. Every 30 minutes, A should call B and know about the status of sale. Every 30 minutes, B should also call A, know about the status of the sale. This is the rule made by a company. Okay, na? Now listen. Monday, place. Monday started. 9 o'clock after they switched on the mobile phone and they kept a message to the company head saying that, sir, we started for work. 9:30 A called B. 10 o'clock B called A. Like that conversation happened till 6 o'clock. Clear? Now I will ask you a question. You answer with some common sense, if any. Tell me. I am the first person, you are the second person. Let's say, for example, I called you in that salesman, I am the first, you are the second. I called you at 11:30. I called you at 11:30. Will you ask me why you called from that mobile phone if I call you? For what purpose I will call you here? Answer. Sale updation. 12:30 I called you. Will you ask, hey, why you called? No, you will not. I called you at 2:30. Afternoon I am talking about. Will you ask, 5:30? Answer. 4 o'clock? 6? No. 10 o'clock I called from my personal mobile phone. Will you ask me why I called or not? Then I will tell I called casually, because casual is something which is not general. That's why even in hospitals, accident what is called as a casualty. It's an emergency case. Casual always represents special cases. It's not general. Indians are using English in such a way. Our body language will change the meaning of the casually. Casually. Casualty means emergency case. Even in hospital, board will be there. Casualty ward. Sudden accidents, all these things will go to casualty. Means what? Emergency, special cases, occurrences. Like auditor's death, auditor's disqualification, removal, resignations. All these things will happen. So hope you understood the meaning of the term casual. Casual is reverse to the word normal. Normal ke how abnormal? Abnormal ke another name is casual in law. Listen carefully. Now, what declaration we are giving here? Listen. This declaration will be a self-declaration. It's not professional declaration. For example, a person is an idiot. Who will know that he is an idiot better? He only will know. Okay? A person is a rogue to the core. Who will know that he is a rogue force? He will only know. Hope you can understand what I said now. So, the main focal point is how much idiot you are. Who will understand? You only will understand. My idiocy I can understand. Your idiocy you can only understand. Your stupidity you can only understand. Example key. Okay. All reverse answers you will give. If I tell one thing, you will give another answer, except one. That's just now. So the point is, listen. Therefore, act is asking the subscriber, say, subscriber, have you done any fraud in the last 5 years? No, then sign on the affidavit. Subscriber, have you been arrested or convicted for breach of duty? Means not doing the duties properly. Have you been convicted and arrested by any person and you are kept in jail in the last 5 years? He said, no. Did you do any kind of immoral activity like theft, all other immoral things? Have you done and arrested in any of the 5 years? No. Sign there. Fourth signature, 3 signatures. Not guilty of breach of duty, not guilty of fraud, not guilty of misfeasance. Everyone repeat, what is the word? Misfeasance. Misfeasance. What is this misfeasance? Listen. English there is a word called as a feasible. Feasible area they will tell. LPPs. Linear programming problems they will tell feasible area. Feasible means acceptable. Tell me. Please, so much noise is coming, sir, please. Feasible means acceptable. Tell me now. Conduct to misconduct. MIS is added, negative or positive? It negates the meaning. Likewise, feasance, acceptable. Misfeasance, non-acceptable behavior. For that, have you been convicted in any of the 5 years? No. Sign on that. I have to make 4 signatures. Signature 1, breach of duty. I am not breach of duty. Number 2, not being guilty of fraud. Number 3, not guilty of misfeasance. Number 4, stating that all the contents of this MOA are correct to the best of my knowledge. you will sign. These are called as which declarations? Self-declaration. How many points we read totally now? 7. Tell me now the point clearly. What is the first one? Summarize and leave. Number 1. I will repeat this declaration point again in the tomorrow's class. Okay, almost main points completed. Number 1. MOA, AOA, signed by subscribers to the memorandum. Number 1 over. Number 2. Address of correspondence till the registered office is established. Number 3. Number 3. Name, surname, residential address, nationality, proof of identity of subscribers to the memorandum. Continue. Name, surname, residential address, nationality, proof of identity, and then and consent and interest in other firms and other organizations in case of first directors. 4 points of 5 points over. 6th one, declaration given by professional advocate, CA, CMA, RCS, and first directors of the company, manager, secretary, etc. They will give about self-declaration of professional. That act rules have been complied with. Last one is self-declaration. So these are all about the main contents. Okay, now next session we will continue. Next session we will do stage appearance, full fun. But once I have to complete all these, once completed, full we will revise everything. Okay, thank you very much. Have a nice day.